Hello, everyone, and welcome to today's Fenwick Elliott webinar. My name is Stacey Sinclair, and we are delighted to be back here again with you today. Thank you very much for joining us. So today we are talking about, of course, expert evidence, an extremely important element for many construction and energy disputes if you're looking for a successful outcome, and quite topical at the moment. I'm not sure if anyone has seen the Law Society's Gazette on the 20th of May, 2022, so just over a month ago. And there was an article in there entitled, "Partisan Experts Can Be Fatal, Supreme Court Justice Warns." In short, Lord Hamblin spoke at a recent conference where he said that experts must avoid the risk of taking sides and advocating for their instructing party. He said that cases where experts were admonished for being partisan by the court have occurred far too often in recent years. He said it's the counsel's job to argue the case. That is not the role of the expert. Never get into an argument with counsel, however provoked you might be. So there we go. Recently, direct from the Supreme Court Justice, and then actually 10 days ago, on the 13th of June, we saw a case in the family court of Gallagher versus Gallagher, and there, Mr. Justice Mostyn, his judgment referenced Lord Hamblin's speech. So quite a timely topic, and we are therefore delighted to have my fellow partner, Edward Foyle, and Senior Associate Hugh Wilkins here with us today to take us through the ins and outs of expert evidence and the lessons from the courts. Both Edward and Hugh are specialists in construction and energy law and all forms of dispute resolution, including litigation, global arbitration, international arbitration, adjudication, all of which, of course, involve expert evidence. So before I pass over to Edward and Hugh, just a few administration points as usual. Everyone is on mute, and you will see the toolbar on the right-hand side of your screen with a questions box. Please do put your questions in that box as we go, and hopefully I can take one or two of them at the end and put them to Hugh and Edward. And do rest assured, very, very hot question always, rest assured this session is being recorded and will be available on our website as an on-demand recording along with the slides in due course. So with that, I will hand over to Edward. Thank you.
Good afternoon, everybody, and thank you for joining us. As you've probably gathered, we are all in separate locations as a result of the rail strikes in London and, well, across the country, preventing some of us from getting into London. And I hope you are not too badly affected yourselves. So, as Stacey has said, expert evidence is a very topical issue. It's something that there's been a series of court judgments in recent years about, so not surprising that it featured in the recent Legal Gazette. There's a real theme in the courts of frustration with the quality of expert evidence that they've been receiving. And it's also, as Stacey said, a really crucial part of construction and engineering cases. Very, very often it's the deciding factor in determining liability for the case. Was work, for example, done in accordance with reasonable skill and care? Those technical issues that appear in construction cases, what is the correct answer technically that the judge is then going to use to determine liability? So it's really fundamental in construction and engineering cases on liability. It's also quantum is another key area where you're going to need expert evidence to guide the court to explain the amount that is recoverable as a result of any breach of contract, and also delay. Very, very common part of TCC proceedings that you would have quantum experts, delay experts, and then any number of technical experts. So it's a crucial part of a party's case and very important to get it right. Ultimately, you want the court to accept your expert's evidence over the evidence of the expert on the opposing side. So I thought I would dive straight in with the thorny issue of the difference between an expert witness in court proceedings and an expert advisor, because that's an important difference to understand. An expert witness instructed in accordance with CPR, Civil Procedure Rule 35, owes his duties to the court and must comply with the civil procedure rules that we are going to talk about in some detail today. An expert advisor is instructed by a client and owes his duties or her duties to the client to give the client an assessment of the strengths or weaknesses of the client's position, and can also assist in advancing their client's case, saying, well, these are the arguments we think are best, these are the arguments which you should run. An expert advisor does not ultimately give evidence in the litigation. An expert advisor plays a very important role because a client will need to know the strengths and weaknesses of its case, and more often than not, when instructing an expert advisor, in order that the client can properly evaluate the strengths and weaknesses of its case, you would say to the expert advisor, please do this, provide your opinion, as if you were giving an opinion in court proceedings, and bearing in mind those duties, in particular the duty to be independent, because that is the way that the client then gets an objective, realistic assessment of the strength of its position, one that it knows will likely hold water when it comes to any later litigation. So instructions to an expert advisor are generally privileged, unlike the instructions that are given to an expert witness. And the expert advisor's opinion will probably, or may, I should say, attract legal advice privilege. That's a separate talk, really. It depends on whether that expert's opinion was produced for the dominant purpose of litigation reasonably in prospect, or if which is litigation privilege, or legal advice privilege if the instructions are issued through a law firm. Fees for an expert advisor are generally not recoverable, unlike fees for an expert witness, which can be recoverable in court proceedings. And if at a later stage in litigation, an expert advisor is then asked to be appointed as a CPR 35 witness, it's sensible to renew the instructions for the expert at that stage. So as I say, absolutely key in any case in the TCC that you have a reliable expert to present to the court. What are the factors that are going to be most relevant when instructing and choosing your expert? Well, clearly he or she needs to have expertise in the issue in dispute, the real point that needs to be decided by the court. You're going to want your expert to have very deep knowledge and expertise of that particular issue. The expert is going to need to be able to communicate well, both in writing when preparing a report, and also at the hearing orally in cross-examination or hot tubbing. And in that regard, you may want to bear in mind their prior experience of court proceedings, because obviously it's not an easy process being put under cross-examination or hot tubbing. So you may be inclined to appoint an expert who's got previous experience of that process. Reputation. Some experts have been publicly named and shamed by the courts as not complying with their expert duties and not being reliable experts, and that may therefore be something to warn you against instructing that particular expert. I think that ties in with the next point, understanding of expert duties. Got to make sure that they know process, and that they're going to comply with those duties during the giving of their evidence. A big sort of practical factor will be how they're going to resource the work that they do. Clearly, senior experts are very expensive, but what use can they make of a team of junior resource to help with that process of reviewing all the documents in the case, which is clearly a very large work stream, but then making sure that ultimately the report that they produce is their own and the named expert is across all the detail of the case. So you're looking for someone there who can work in an efficient team. Availability, obviously a factor, because you don't want your expert's availability to delay the proceedings. And similarly, conflicts, you don't want to later down the line find that your expert is conflicted and need to appoint another expert as a consequence, which would lead to unnecessary delay. So just the reason why we're giving this talk today on expert duties and compliance with them, the reason it's important is if your expert has not complied with those duties and the court reaches that finding, the court will have a number of options, and one of them is to give little weight to that expert opinion and prefer the expert opinion given by the other side. Another possibility is if an application is made in the lead up to a hearing that an expert has not been complying with its duties, the court can deny permission for a party to admit that expert evidence and say that expert evidence can't be relied on at all. So it gets struck out entirely. And I think the point to note there is that parties in TCC litigation can't just put in an expert report as you might do in, say, adjudication proceedings. You need to have the court's permission to file expert evidence on a particular issue, and that is required under CPR Rule 35.4. As I said before, really important that the expert answers the right question, and that I think is the interface really with the legal team, who need to look at the case and say, okay, what's the issue that's going to determine liability here? What is it that the court needs answered? Make sure that the expert instructions require the expert to answer that particular question, and that the expert is suitably qualified to do so. We now have the civil procedure rules, which were issued in 1998 and came into force the following year. Prior to that, the expert duties were set out in common law, and Justice Creswell summarised them here in the Icarian Reefer. And every expert should be familiar with this passage of the judgment in the Icarian Reefer, which I think provides a bit more meat to the principles than you see in the CPR, and remains good law. So the key requirements summarized here is that the expert evidence must be the independent product of the expert, uninfluenced as to formal content by the exigencies of litigation, so it's got to be entirely independent. Number two, the expert should provide independent assistance to the court by way of objective, unbiased opinion in relation to matters within his expertise. He should never assume the role of advocate. An expert should state the facts or assumptions upon which his opinion is based. So it must be clear to the court what the expert has considered, what he's relied on, and what he hasn't. An expert should make it clear when a particular question or issue falls outside his expertise. If an expert is giving a provisional opinion, he must indicate that his opinion is no more than provisional, and any qualification should be stated. any change of view should be communicated through legal representatives to the other side without delay. And number 7, all documents and other information that the expert refers to must be provided to the other side at the same time as the exchange of reports. So those remain good law, but have been also reflected in Part 35 of the Civil Procedure Rules, which parties in court litigation must comply with. I've just picked out a few of the key requirements of Part 35 on this slide, that the expert evidence should be restricted to what is reasonably required to resolve the proceedings. An overriding duty by the expert is owed to the court, not to the client, who of course pays his fees or her fees. The court's permission is required for expert evidence to be admitted, and the court may specify the specific issues that the evidence expert opinion should be limited to. And the court can direct that information be shared to another party. And here we have TCC also saying that as far as possible, experts must cooperate fully with one another. I think really this slide just repeats in practice direction 35 the guidance that you see in the Icarian reefer. It's very similar, and I don't think there's any need for me to speak to it. This is an interesting point in the practice direction, that where there's a range of opinions on matters dealt with in the report, the expert should summarize the range of opinions within the industry and give reasons as to what would be an appropriate answer, and give his reasons for his own opinion within that range. It's also a requirement that the expert report include a statement of truth. Sir Robert Aikenhead is a former head of the TCC, and in a 2014 article, he identified the following points as key attributes for an expert evidence for an expert. And clearly, as head of the TCC, this is something he's speaking from a position of great experience. So his real gripes were: does the expert have relevant expertise? Are you in fact finding that the expert turns out to be a jack of all trades, that's to say he's got expertise in a broader area than the particular issue that needs to be addressed? For example, he might be a civil engineer but not have technical expertise in the real issue in dispute. Or is the expert perhaps enjoying a semi-retirement and no longer practicing? As a result, is that expert up to date with the issues and developments in the field? He says the courts can always spot a hired gun. Independence and impartiality is crucial and very easy for the client to spot, for the court to spot when those duties aren't being complied with. And I think related to that, he stresses that the willingness to concede points by an expert is really important, and goes to their whole credibility of their evidence generally, if they're willing to engage with points made by the other expert or by opposing counsel and concede where they believe they're wrong, where it transpires they may an opinion they may previously expressed may be wrong. And finally, it really irritates the courts if experts don't get the basics right. So that would include the facts of what happened on the project, or facts of what the other expert may have said in their opinion or been alleged in pleadings. So important to get that right. Obviously, one of the most fundamental principles that an expert must comply with is to be independent, and I think it's important to bear in mind this definition of independence given in the Guidance for Instruction of Experts in Civil Claims 2014 and referenced in Practice Direction 35, which is that a useful test of independence is that the expert would express the same opinion if given the same instructions by another party. And just by way of example of that's application, you have in the 2021 case BT Passive Norse and Canham Consulting, Mr. Justice Fraser preferring Mr. Evans' evidence over that of his opposing expert, Mr. Hughes, on the basis that Mr. Evans gave the impression that his evidence would have been exactly the same had he been instructed by the claimants, whereas Mr. Hughes did not and sought to advance the claimant's case at the expense of objectivity. So that is the test for independence that all experts must bear in mind. So I'm now going to hand over to Hugh, who is going to talk about 4 recent judgments in the TCC, and then I'm going to say a word about expert shopping after he's been through these cases.
Thanks, Ed. As Ed mentioned, I want to look at 4 cases from the last 5 years, judgments that have really shone a spotlight on the experts involved and how some of them fell short in the performance of their duties to the court. First one is the Governor and Company of the Bank of Ireland against Watts. The case arose from a scenario where the developer had borrowed money from the bank, subsequently gone into liquidation and couldn't repay the loan, and the bank sought damages for professional negligence against Watts, the quantity surveyor it claimed to have relied on in approving that loan. Now, as with the case with many negligence cases, both parties instructed and relied on experts, in this case, quantity surveying experts, and their evidence was key to the question of whether Watts had acted negligently or not. And Mr. Justice Coulson devoted a section of his judgment to the bank's expert, who he found was not properly independent. Now, the bank was his principal client and provided him with the vast majority of his work and fees over the last few years. And that close relationship with the bank was evidenced in a number of ways that I've listed down here. The expert adopted an unrealistic approach to the allegations and attempted to mislead the court when quoting selective words from a passage in RICS guidance so as to distort the meaning of that passage. The expert also applied the wrong test and adopted a thoroughly unreasonable approach in refusing to make any concessions in discussions with his opposite number or during his oral evidence. And many of the criticisms he made of Watts were so unpersuasive that the bank declined to even plead them, and yet he continued to make those criticisms in his expert report and up to his oral evidence. Now, I next want to look at one of those particular criticisms, being that he applied the wrong test. Now, the main criticism of Watts was that it had endorsed the borrower's estimate of construction costs, a figure of about £1 million. For that service, Watts had charged a fee of £1,500 to produce an initial appraisal report, which the bank claimed to have relied on when agreeing to make the loan. So they were only carrying out an overview process. They weren't appointed to effectively build up their own cost estimate from the bottom up to verify that £1 million. That being the case, the questions for the parties' experts were, what would a reasonably competent monitoring surveyor have done in those circumstances? And how did Watts perform against that benchmark? But what the bank's expert did was produce his own detailed calculation where he went through every line item and worked out his own figure for that line item. And he said that first of all, he said that Watts should have done that rather than do just an overview. And second of all, that if any figure in his line-by-line analysis wasn't adhered to, so if Watts had a different figure for anything, any of his line items, then Watts must have been negligent. So there's no margin for error. He was the sole arbiter. If his figure was right, anyone else's figure would be wrong. And based on the various criticisms that were made of the bank's expert, the judge decided that where there was a disagreement between the experts, he would prefer the evidence of Watts's expert rather than the bank's, and the bank's claim failed. And the next case I'd like to look at is the case of ICI and Merritt Merrill. So MMT was a specialist engineering piping manufacturer and entered into a contract with ICI for works associated with the construction of a new paint manufacturing facility in Northumberland. The original value was approximately £2 million, but that didn't include any of the pipe work that would be required because it hadn't been designed at the time the contract was entered into. There was delay to the project and a very significant increase in the value of the works. And in a previous judgment, the court heard and decided that ICI's parent company decided that the best way to bring the project cost down, which was its aim, was to push MMT towards insolvency, and repudiated the contract with MMT. So that was previously decided, and the question before the court in this instance was, what was MMT entitled to as a result of ICI's repudiation, and specifically, what was the value of its works at that time, and what damages flowed from the wrongful termination. Both parties instructed two quantum experts, a quantity surveying expert for valuing the works and an accountancy expert for valuing the damages flowing from termination. And the same judge heard the case on quantum as for liability, and in his judgment on quantum said that the correct approach for the experts was to consider, the correct approach for the experts in order to consider the valuation of MMT's works at the point of termination was to consider the liability judgment and take express note of the findings in it, to consider contemporaneous agreements reached between the parties, and to consider the factual evidence and conduct, and to conduct at least alternative valuations on the basis that the court may accept either of the two sets of facts. Now, both of ICI's experts were heavily criticised in Mr. Justice Fraser's judgment, and I want to first look at the criticisms he made of ICI's quantity surveying expert, who was a well-known, well-qualified and very experienced expert. But Mr. Justice Fraser said that passages of his report demonstrated a failure to grasp the essential requirements of his task, which was to perform an independent valuation of the works and not to argue the case for ICI or to adopt points in a partisan fashion. Now, one criticism was that he had taken issue or taken points of fact and law which were actually for the court to decide. So there was detailed factual evidence about how the parties had priced the works throughout the project and how they had actually reached agreement on certain items which now fell to be in dispute. The judge said whether those rates and agreements were binding or not was an issue for the court, but ICI's expert just chose to disregard them entirely. He also ignored a schedule of rates which had been used throughout the project, as agreed between MMT and the project manager. He decided instead to use actual cost. Now, there wasn't a contractual basis for using actual cost, but he justified it, saying that in his view, to use anything other than actual cost would be to give MMT a windfall. He also ignored evidence from MMT's witnesses of fact who'd been involved in the project at the time, as well as contemporaneous documents in favour of his own view, even though he wasn't instructed until well after the contract had come to an end. And Mr. Justice Fraser said that this wasn't the type of evidence an independent expert should give. What this expert was trying to do was rewrite the parties' contractual bargain. Another criticism was that there were certain circumstances and line items where ICI's expert felt he couldn't support either party's valuations, but said that all he could do was prefer ICI's valuation. And what he should have done instead was to provide alternative valuations, one on the basis of the facts as set out by MMT and one on the basis of facts set out by ICI. And he had also given witness statements in support of previous disclosure applications, which the judge said such applications should really be left to the parties to make and support. He also criticised the evidence that the expert had given in those applications. And I've just got a quote here where the judge said there was a remarkable contrast between the quality of the expert valuation evidence from the two quantum expert evidence. He found MMT's expert a reliable and independent one and preferred his evidence in all respects. Then turning to ICI's accountancy expert, again, there were a number of criticisms laid at his door. First of all, he'd been instructed to opine on causation and whether costs incurred by MMT switching banking facilities were caused by repudiation by ICI. Now, the judge said this was an issue for the court, not an expert who is there solely to value what those losses might be. And whilst the expert couldn't be blamed for his instructions, being asked to opine on causation, he could be blamed for the way in which he had followed them. This expert was also criticised because his report was peppered with statements demonstrating him taking a partisan stance, including in contradicting findings made by Mr. Justice Fraser in his previous liability decision. He made the same criticism as of the QS expert, that where there are two versions of the facts, experts should consider them both. It's not for them to choose which is correct. That's for the court. He had also made factually inaccurate statements about his opposite number. For example, he'd said in his report that his opposite number had agreed that further information was needed to fulfill her own instructions. But actually, during the joint statement process, this issue had arisen, and ICI's expert had suggested making a disclosure request for further information, and MMT's expert had said it wasn't necessary. No additional disclosure was necessary for the purpose of her fulfilling her instructions. Despite that, ICI's expert maintained in his report that she had said that the further information was required, and unsurprisingly, perhaps the court took a very dim view of that. Now, interestingly, this expert had been subject to judicial criticism previously, and Mr. Justice Fraser acknowledged that simply because an expert has been criticised by a court before doesn't mean they can't learn from their mistakes and give reliable and helpful evidence in in a future case. But he said that the previous judgment demonstrated he'd given partisan evidence before, and that now he could see that he hadn't changed his approach. Interestingly, having now been criticised twice, this expert might find it difficult to persuade a tribunal of his independence in the future. Now, the next case I would like to look at, before that, I have just left two quotes from Mr. Justice Fraser's judgment here, which I thought were pretty interesting. The first one emphasising that it's for experts and legal advisors to make sure that they know and understand the principles that govern expert evidence, and that there's a lengthy practice direction to CPR 35. Every expert should read it. And secondly, there are some jurisdictions where partisan expert evidence is the norm. For the avoidance of any doubt, this jurisdiction is not one of them. Now, the next case I'd like to look at is Dana and FST. Now, this was the end of a long-running argument about the adequacy of FST's disclosure and expert evidence. Dana had complained various defects in FST's expert reports. The expert hadn't identified documents on which he'd relied, and there was no list of documents. Two of FST's experts had undertaken site visits to FST's factories without putting Dana on notice or affording their experts the same opportunity. And when referring to data and information, FST's experts didn't always provide a reference for the documents they were relying on. All of this was really significant because there had been issues with disclosure, and the plant in question was FST's plant. Dana wasn't familiar with the manufacturing processes there, and so in circumstances where FST were able to visit the plant, speak with those working at the plant, and Dana weren't afforded the same opportunity, there was a real imbalance between the parties. There was much toing and froing, and the court ordered FST to provide certain categories of documents, and then when it got to the hearing, the Dana weren't satisfied that the terms of the order had been satisfied, and sought for FST's experts' evidence to be disregarded. And the court reached a decision based on FST's compliance with the terms of the order, but also made some comments on FST's compliance with the CPR. And I just want to look at those quickly. The court emphasised that experts are only able to give evidence with permission from the court, and that the expert's overriding duty is to the court, and that overrides the duty to the client, as Ed mentioned earlier on. But also made the following criticisms of FST and its experts, and interestingly, it's of not only of the experts but also of FST. There was a free flow exchange of information between the experts and FST through extensive emails, calls, and site visits, and there'd been no, if any, oversight of this flow of information from instructing solicitors. So the court couldn't be satisfied that the expert's report stated the substance of all material instructions. FST had also been in contact with their experts during the negotiation of joint statements, which the court recognised that the TCC guide makes clear that legal advisors should not be involved in negotiations or drafting joint statements, but were silent on parties themselves. The court said it was obvious that it also applied to the parties. A really significant criticism is that two of FST's experts had attended the site without informing Dana's experts, and that Dana's experts hadn't been afforded that same opportunity. And so it really caused an imbalance in their level of knowledge. And finally, that documents revealed by one of or documents disclosed revealed that one of FST's experts had actually started his opinion by reading through FST's comments in order to inform his opinion, and then asked FST to correct any mistakes or misinformed opinions. And the judge said that these showed a blatant disregard for an expert's duties, and that these breaches alone would be sufficient to justify the refusal of permission for those experts to give evidence. And finally, very briefly, I want to just touch on the case of Patricia Andrews, in which was just earlier this year. And this is a case where the defendant, it came to light that the claimant's expert had been in contact with the claimant's solicitor during the period of joint statement discussion. The expert had provided various iterations of the working draft of the joint statement to his instructing solicitors, who commented on those drafts, providing 68 comments, most of which were typos, but at least 16 of which were comments and suggestions on issues of substance. Now, the claimant acknowledged that it was wrong for an expert to ask for advice from their instructing solicitors, and also wrong for the instructing solicitors to provide input requested, and that there were serious transgressions of these rules. So the question really was what sanction should apply. And the court decided that there had been continuous contact between the two, and that the claimant's expert's approach strongly suggested that he regarded himself as an advocate for the claimants rather than an independent expert whose primary obligation was to the court. As a result, the court had no confidence in that expert's ability to act in accordance with his obligations, and withdrew permission for that expert to give evidence. I'll now turn back to Ed, who can talk us through expert shopping.
Thank you, Hugh. I think those are 4 very good illustrations of the importance of complying with expert duties, and we're going to, I think, in a minute summarise where we think we are with the CPR 35 duties and what those cases show. But before we do, I'm just going to have a quick word about expert shopping and the case of Rogerson and Eco Heat Power, which was a case last year. So expert shopping, by that I mean changing your instructed expert for tactical reasons. In other words, he or she has produced a report that doesn't support your case, and you therefore no longer want to call him as your expert in the proceedings. Now, the key point here, I think, is that, as I mentioned earlier, the court's permission is required to call an expert. So if you've got one expert named and you're then saying, well, actually, I'd like to call somebody else, you need the court's permission to do so. And there are a series of Court of Appeal judgments, 2 in 2005 and Edwards Tub, I think, is a 2011 case, which really show how much the courts hate expert shopping, the replacement of experts. And I think that the reason is any expert instructed for proceedings is required to give an independent opinion. So it seems to me the courts really feel they should have sight of that opinion, and the idea that somebody is changing their expert, they hate it. So they've said, changing your expert, fine, you can do that. However, if it appears that you're doing it for tactical reasons, effectively the price that a party needs to pay is to waive privilege over the report that was produced by the original instructed expert. That is the Court of Appeal decision in Beck. And then the other case in 2005 with the name I'm not going to try to pronounce, the court said, well, it's not just the final expert report that's privilege should be waived over, it's anything showing the substance of that expert's opinion. So it actually need not be a report. It's anything anything recording the substance of that previous expert's opinion you need to give to the court if you're going to replace that expert with another expert of your choosing. Edwards, Tubb and Wetherspoon, Lord Justice Hughes then went on to say, well, there's no real distinction in principle between an expert instructed before the issue of proceedings or an expert instructed after the issue of proceedings, because their report should be exactly the same, because that expert, even if instructed before the issue of proceedings, if he's instructed to provide an opinion for the court, his duty or her duty in producing the report is unequivocally to the court. It should say the same. Doesn't matter whether proceedings or not have been issued. By contrast, there at the end of the slide, an expert consulted but not instructed to write a report for the court. So that's an expert advisor, as I began this webinar by talking about, is in a different position. So Matthew Rogerson and Ecotop Heat is an interesting case, because it's quite surprising, really, I think, the judgment, how far back the court said this principle could apply. Just picking up on the Edwards, Tubb and Wetherspoon and Lord Justice Hughes point, it goes really quite a long way further than I think one might imagine the court would consider when considering whether expert shopping had occurred and whether the price of waiver of privilege should be paid. So the background to this case is it related to a fire at a hotel that occurred on the 11th of June 2018, and 2 days later the contractor confirmed that it was taking steps for the involvement of an expert forensic fire engineer. Then approximately a week later, Dr. Nagalingham was named as the instructed expert for the fire investigation. There were joint expert meetings attended by Dr. Nagalingham, and allegedly at those meetings he indicated that it was hard to see anything other than a cigarette was the cause of the fire, which was detrimental to, or would have been detrimental to, the contractor's case, because there was an allegation that the fire had been started by a cigarette, and it appeared likely that that would have been by one of the contractor's workers on site, although that wasn't proven. After that expert meeting, he continued in October to have further exchanges with the claimant's expert, and also to have a meeting with the contractor's solicitors, in which he gave the contractor's solicitors his view on the cause of the fire. He never produced a written report, but he did have that meeting in which he told them what his views on causation were. So it wasn't until some time later that proceedings were initiated. So, and by initiated, I mean pre-action stage, not formal issue of a letter of claim. And in the pre-action letter of response, the contractor is required to say whether a defendant is required to say whether it intends to call any expert evidence and any expert it relies on. And the contractor's letter of response did not identify that it had instructed any expert. And then in the advance of the CMC, a further year later in 2021, the contractor submitted its draft directions, and under CPR 35.4 sought permission to call a different expert, Miss Wilson. Now, the claimant jumped on that and said, "You've changed your expert. This is expert shopping." And they applied for disclosure of any reports or opinions expressed by Dr. Nagalingham. having trouble moving the slide on. Not sure why. Stacey, are you?
I'm going to try and sort that out, Edward. Whilst maybe if you carry on.
Yeah, no, I can carry on. No problem. I don't have that. I actually have the deck with me, but this disclosure of the report was ordered, and excuse me, disclosure of the record of the meeting on 2nd of October was ordered, and I think that is quite a surprising result, really, given how long ago it was that Dr. Nagalingham had his involvement in the case. But I think there are a few crucial factors that influenced the court's opinion in reaching that decision. First of all, Dr. Nagalingham's instructions were never disclosed, so it was unclear in what capacity he had been instructed. Second, it seemed to the court that he had been instructed to provide an expert opinion because he continued to have expert meetings with the claimant's experts at a time that litigation was assumed to be contemplated by both parties. And he gave no real evidence as to what his instructions were either, in addition to not disclosing the report. So those, I think, were the factors that influenced the court. See if some later ones appear on the slides when they emerge. And I think that the lesson here is, I think, which
I'm going to try and get you back to the slide that you're on, Edward.
Okay, thanks so much.
I think we're just having a bit of a time delay issue or connection issue.
So I think really the lesson there is to take great care when you're instructing your expert the terms on which they're instructed at the outset, because clearly there was an immediate need for a fire expert to be instructed. Had the contractor been able to produce the instructions for Dr. Nagalingham and show that he had been instructed in an expert advisor capacity, I think it very unlikely he would have been ordered. It would have been ordered that his report be disclosed. So I think, Hugh, I'm now going to hand back to you for your summary of where you think we are with the cases, and how, if anything, they build on the CPR which was issued in 1998.
Yeah, I think the recent cases, and what they really do is add detail to the CPR and its associated practice direction, the TCC guide, and other guidance about what an expert's duties and obligations are. But I think there are a few that are really important. It's really important to control the information that's provided to experts, so that there's a clear record of what is provided. Equally, it's really important that experts are on an equal footing. So documents disclosed to one expert should be, and relied on by that expert, should be provided to the other side. And also, if one expert is given the opportunity to attend the site, then that opportunity should also be given to their opposite number as well. And for experts in particular, when you are preparing a report or giving evidence orally, it's important not to be really careful about the facts. As Ed said earlier on, get the basics right, and getting the facts right is part of that. So don't contradict the court's previous findings of fact if you're in a bifurcated hearing, and don't prefer one set of facts over another. Consider both and proceed on that basis, as if either could be, and give your views on each on the assumption that each one is correct. Don't just prefer your client's evidence over the opponent's. And then on the slides, we don't need to go to it, but I've put some comments by Mr. Justice Fraser from his conclusions in the ICI and Merrill case, which will be and you can get a copy of these slides after the talk, where you can read exactly what he had to say about some examples of applying the CPR and the Arcadian reefer in practice.
Thanks, Hugh. So I just got a final slide here with some top tips on expert evidence. As I said, really think about the issue that the expert needs to address. How is that going to help the court? What's the issue that the court needs to decide, and what's the test that the court will apply when deciding that issue? How can your expert help guide the court in answering that test? So that's something for lawyers and the client to think about together, and make sure experts are answering exactly the right question in the right way. Really important for persuasive expert evidence is that a report demonstrates how conclusions have been reached and how they've been supported. Obviously, that will make the report read well, but it's important as well for the expert when being cross-examined or in a hot tub, that he can say, well, actually, the reason I've reached that conclusion, I've got it here right in front of me, my report, it's section, whichever section it is, because you can't say under cross-examination, oh, it's a perfectly reasonable conclusion, I reached it, but it was a member of my team who did all the work, and I don't have that in front of me, and it's not been put in these proceedings. Very important that everything is clearly set out. Hugh's already talked about the final point, that point there, about considering the other party's cases factually and providing a view on the outcome if they're right. Preparation of the report and preparation for cross-examination. It's that balance that I talked about at the beginning, about especially in big cases, an expert being across all the detail, but also having a supporting team that will have helped the expert digest all the information and documents from the projects and really boil it down into conclusions that the court can use. I mean, we often think of cases being built up in a pyramid structure with at the top of the pyramid you've got the points that are made in submissions, and underneath that you've probably got the conclusions that the expert made. Underneath that you've got witness evidence summarizing what happened, and underneath that you've got all the documents and records from the case. So it's a very big role digesting all that information, and the expert will require assistance, but at the same time it's to be absolutely prepared for the report, to prepared to say how the report was produced. And related to that really is taking care, saying, I have considered all these documents, I have done all these things, making broad brush statements in an expert report. If under cross-examination it later transpires that certain categories of documents had not been considered, then clearly that gives the impression that the report is misleading, and therefore the court won't be able to rely on it, because it will give the impression that the report has not been prepared with due care and attention. Even if that is only one small aspect of the report, it can have a detrimental impact on the credibility of the evidence as a whole. The final point we've talked about already, that willingness to concede points goes a long way to establishing an appearance of, well, to being credible, to showing that you're complying with your duty to the court and being entirely reasonable in your evidence. So that's the end of our talk today. Thank you very much for listening. We have taken a full hour, but if people are willing to stay and if there are questions, we're more than happy to answer them.
Thank you, Edward and Hugh. Edward, I can see that you have moved the slides onto the question, question and answer slide, but we seem to be having a delay in the system. But anyway, Edward and Hugh, thank you very much for what I hope our audience would agree with me when I say a very helpful and very thorough review of expert evidence and what lawyers, our clients, the parties to a dispute, and experts need to keep in mind and be aware of. So I think we are at time. I think maybe we just do one real quick question, and I have no doubt Hugh and Edward, you'd be okay with responding to quite a few questions that we've had come in during the course of this session separately outside. So just one real quick question. I'm going to take what are the consequences for an expert or law firm if an expert is found not to have complied with their obligation under the CPR?
Shall I take that, Ed? So obviously we've talked about the implication for the client that the evidence of the other expert might be preferred, or they could have permission for that expert evidence withdrawn, which will obviously harm their prospects of success. But for an expert, there's obviously the risk of a claim in negligence by the client. Being referred to in a judgment is going to cause serious damage to reputation, potentially impacting future instructions, certainly if it happens more than once. But also in the most extreme cases, there can be third-party cost orders made against an expert. There was a case last year including Liverpool University Hospital NHS Foundation Trust, where the claimant's expert was ordered to pay a cost of, I think, £55,000 because his expert evidence had been shown to be completely unreliable. You can also be there are potential disciplinary proceedings by a professional body for failure to comply with the rules, and also in really extreme circumstances, contempt of court or potentially perjury, although I think it's hard to see how, obviously possible, but extremely unlikely that those should be come into play. And finally, for the law firm, obviously there's a risk of losing a client who could be very unhappy, and again, a claim of negligence. And there are in a few of the cases that I talked of, the law firms were named and shamed, and so there's obviously a damage to reputation for the law firm as well. I think that probably covers it.
I think it's quite interesting, Hugh, isn't it? And you and I have discussed this before, that the courts are clearly very frustrated with the quality of expert evidence that they are receiving, and there have been recent changes to the CPR for some aspects of proceedings, thinking in particular of witness evidence, which make it very stringent and impose quite strict requirements on lawyers when taking witness statements. But actually the CPR doesn't really say anything about what the lawyers should do, other than reminding experts of their duties. And you wonder whether this might be an area that is reformed and new rules come in on the taking of expert evidence if the courts continue to be as frustrated as they have been in these judgments that you've run through, because the sanctions there are no sanctions, as it were, on law firms. Never heard of a law firm being fined or in a way that an expert is.
Super. Thank you both. That's been fantastic, and I'm just mindful of the time, and thank you very much to our audience for hanging on with us and for the slide issues we have had. But I think that takes us to the end of the session. Again, a copy of these very thorough slides and the on-demand recording will be available on our website in due course, so you can download them there. And again, Hugh and Edward will come back to the other fantastic questions we've had. So thank you again for submitting them. And so I think if the slides want to move on, the last thing I'd like to do is just to market our next upcoming webinar in the middle of July. That'll be the 14th of July with our senior partner, Simon Tolson, and partner David Bebb, where we will be discussing the new Building Safety Act 2022, which received royal assent on the 28th of April. Which of course has wide-ranging implications for the construction industry in the UK. And they will be discussing, which I know will be a very lively debate about what you need to know. So I do hope you can tune in with us on the 14th of July. You can find the registration at that website link there, fenwickelliott.com/events. And if you want to subscribe to other upcoming webinars and other events, and indeed our know-how and newsletters, I've put the link there for you on that slide too. So thank you very much, Hugh and Edward, and thank you very much to our audience who are from all over the world today joining us. And we wish you well and safe wherever you might be. So thank you again, and we hope to see you sometime soon.